So an assault weapon ban case is now up to the Supreme Court for review. So let's talk about this. But real quick before we jump into this video, if you think that bans on so-called assault weapons violates our Second Amendment rights, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main supporters of the channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. Also, I want to let you know that this content is powered by the Firearms Policy Coalition. So head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So like I said in the intro, an assault weapons ban case is now seeking review from the Supreme Court. The case we will be talking about in this video is Bianchi v. Frosch, and it is a petition joined by Firearms Policy Coalition up to the Supreme Court. The petition is asking the United States Supreme Court to strike down Maryland's unconstitutional ban on so-called assault weapons. As you would expect, if the Supreme Court takes up this issue, it would have major implications not just for Maryland, but also other restrictive states like the state of California and the state of New York, who also have bans on so-called assault weapons. Now for some quick background on this case. The state of Maryland identifies certain rifles as so-called assault weapons. Maryland bans the sale, transfer, or possession of semi-automatic centerfire rifles with detachable magazines and two offending features like a folding stock, a grenade launcher, or a flash suppressor. It also bans a semi-automatic centerfire rifle with a fixed magazine that can accept more than 10 rounds. The state also bans a semi-automatic centerfire rifle that has an overall length of less than 29 inches. And to top it all off, the state also bans a list of 45 named type of rifles. This structure is similar to what states like California do, where they ban a list of make and models of firearms as so-called assault weapons, and then they also ban various rifles based on characteristics they have as also so-called assault weapons. Maryland is no different. They also have a category ban and also a characteristic ban. These Maryland laws were challenged in a Maryland district court in this case. In the complaint, the plaintiffs conceded that their Second Amendment claim was foreclosed at the district court level based on a prior Fourth Circuit decision on this whole issue of the constitutionality of this ban on so-called assault weapons. A prior case called Kobe challenged Maryland's assault weapons ban. In that case, a district court upheld the law using intermediate scrutiny. On review, a divided panel in the Fourth Circuit concluded that these rifles are protected by the Second Amendment and that the ban substantially burdened the right to self-defense within the home. On that basis, the panel there struck down the ban using strict scrutiny. Well, the state didn't like that, so they sought an en banc review in the Fourth Circuit. On review, the en banc panel upheld the state's ban, finding that these rifles are outside the ambit of the Second Amendment because they are useful in military service. The Bianchi case here concedes that Colby is the controlling precedent, but that it is incorrect and should be reversed. The district court, in reviewing this case, ultimately dismissed the complaint for failure to state a claim based on that prior precedent. That dismissal was then appealed up to the Fourth Circuit, and the Fourth Circuit on review once again upheld the dismissal based on prior precedent. And now this case is up to the Supreme Court for review on this whole issue of whether or not Maryland can ban these so-called assault weapons. Now the question presented to the Supreme Court in this petition is whether the Constitution allows the government to prohibit law-abiding, responsible citizens from protecting themselves, their families, and their homes with a type of arm that are in common use for lawful purposes. The three arguments made on why the Supreme Court needs to hear this case are: first, to resolve the conflict in the lower courts over the constitutionality of laws banning commonly possessed arms; second, because the decision below is flatly inconsistent with Heller; and third, because the question presented is exceptionally important. So let's take a look at some of these arguments that were made in this petition. The first argument in the petition is that the Supreme Court needs to review this case to resolve the conflict in lower courts over the constitutionality of laws banning commonly possessed arms. In this section, it is argued that the lower courts are all over the place and divided on the constitutionality of these types of bans. The Fourth Circuit has the Colby decision that I mentioned prior that has upheld this type of ban using intermediate scrutiny. That type of analysis has also been followed by other circuits, 5 other circuits, including the First, Second, Third, Ninth, and DC Circuit courts. All these circuit courts have upheld similar bans on common arms using a watered-down intermediate scrutiny analysis. In contrast, you have courts like the Massachusetts and Illinois Supreme Courts who have followed the categorical approach. These courts have held that laws which bar all civilians from possessing or carrying stun guns, even in their homes, is inconsistent with the Second Amendment and is therefore unconstitutional. They reason that because those instruments are arms within the protection of the Second Amendment, they may be regulated but not absolutely banned. Under this type of analysis, a state's ban on an entire category of protected arms can never be upheld. Again, very different from the tiered scrutiny approach that courts like the 4th Circuit and 9th Circuit have used in the past. Then you have the 7th Circuit that has used a completely different test. They use a test that looks at whether a regulation bans weapons that were common at the time of the ratification, and then they also look at whether they maybe have some reasonable relationship to the preservation or efficiency of a well-regulated militia, or whether citizens retain adequate means of self-defense. As you can see, lower courts are all over the place when they use different types of analysis. They can't decide on what they are actually supposed to do, and because of that, the argument is here in this petition that it's time for the Supreme Court to review this issue and resolve this whole conflict. The second main argument is that the Supreme Court should review this case because the Colby decision is flatly inconsistent with Heller. The argument is that the Supreme Court was explicit about the guiding test for determining the Second Amendment's application to laws that ban certain types of firearms. The question is, has the government banned firearms typically possessed by law-abiding citizens for lawful purposes, or has it instead banned dangerous and unusual weapons that are highly unusual in society at large? If the answer to that question is the former, then the ban must be struck down. This is because the Second Amendment right applies to certain types of firearms, and citizens must be permitted to use them for core lawful purposes like self-defense. The semi-automatic rifles that Maryland bans, like the AR-15, are common under any definition. These rifles are legal in a majority of states, outside of these few restrictive states, and there are over 20 million in possession of law-abiding Americans across the nation. However, even the Maryland court did not deny they are common, but instead tried to say they are similar to the M16 and therefore should be banned. That, however, directly flies in the face of the text as informed by history and tradition of the Second Amendment. The founders intended to protect arms that ordinary citizens would bring from their homes to the militia for duty. So to say a state can ban them because they could be used in the military for military-style uses does not actually find support in the history of our Second Amendment or in the history of our nation. In fact, those are the exact type of firearms that this amendment was intended to protect. The last main argument made in the petition is that the court should hear this case because the question presented is exceptionally important. And this can be really summed up by the first sentence of this section, because this issue concerns the constitutional right to possess in the home the most popular rifle type in all of the nation, owned by millions of Americans for self-defense. Yet the nearly 85 million people living in Maryland and the 5 other states like the District of Columbia or areas like the District of Columbia with similar bans on common semi-automatic rifles are flatly prohibited from keeping or bearing these arms solely because they live on one side of a line, and if they were to move to another side of the line, all of a sudden now they can possess these types of arms. It's also argued in this section of the petition that this case is exceptionally important because the military use analysis the 4th Circuit used will result in eliminating the type of arms the founders actually intended to protect. It also puts at risk a lot of types of other firearms, like for example, Glocks or SIGs or really any other type of firearm that maybe the military uses. All of a sudden, now a state or a court could say, these are military type firearms, they're used in the military and therefore we can ban them. So this is an interesting and important case, and if the Supreme Court decides to actually review it, it will have major implications not just on the state of Maryland, but will also impact other states like California and New York. So we'll be keeping our eyes on this, and if there's any major movement, I will definitely let you guys know. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and it signals to YouTube that you guys see value in these videos and in this type of 2A news. So thank you so much to everybody who's liked, commented, subscribed, who's hit the notification bell. You guys are directly impacting these videos, impacting this channel, helping me to reach more people than I could have ever thought. I never would have thought I would have been anywhere near 200,000 subscribers by the end of this year, but because of you guys, I have been actually able to reach over 200,000 subscribers, and we are still continuing to grow. So also, if you're a longtime lurker or if you're a new subscriber, make sure you comment down below that you're a new subscriber, and I will make sure I comment back to you. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.